Thank you for choosing View Legal to implement your estate planning arrangements. My name is Tara Lukey and I'm joined with Matthew Burgess. The purpose of this video is to step through the key provisions of your will. Throughout the video, we'll show you a sample will on the screen, which will be very similar to your will. During the online meeting, your View Legal lawyer will point out any aspects that are different to the sample will.
Hi, my name's Matthew Burgess. The purpose of the online meeting that you'll attend is to make sure that all of your instructions have been reflected in the documentation, step you through the documentation and get you comfortable with it, and where necessary, get any changes made before we send the material to you for signing. One thing to note is that the entire meeting will be recorded, so if you've got any concerns at all with that approach, please make sure you raise them at the start of the online meeting.
Turning to your will, I want you to make sure that we've got your name and address spelled correctly. If there are any changes, please mention it to your View Legal lawyer during the online meeting. The same goes for any other names throughout the document. Please let us know if they're not correct.
You'll see in the overview section that the will, as soon as you sign it, will automatically revoke any previous will that you may have done. The other really big thing to understand is that the will only regulates assets that you own personally. And what this means is that if you own anything via a superannuation fund, assets inside a trust or a company, or indeed assets that you own personally but you own them as joint tenants with someone, they will not form part of your will. If you've got any concerns in this regard, make sure you raise them as part of the online meeting.
I'd like to talk to you about the definitions section. Throughout the will, you might see that there are particular words that are capitalised in an unusual place. This means that they are defined terms and their meaning is set out in the definitions section. I'd like to talk you through some of those key definitions now. The first one is the gift over provision. If you've nominated a gift to go to a particular person in your will and that person has not survived you but has children who have survived, then if the gift over provision applies, then those children are going to take the gift of their deceased parent. You might see throughout the document that there are comments that the gift over provision does not apply. This is because there is a presumption in the document that the gift over provision does apply unless specifically stated. Another useful definition is LPR, which stands for Legal Personal Representative. This just means you're executors and trustees of your estate. You'll also see net estate used throughout the document. This just means all of your assets at the date of death, minus the liabilities, which are available for distribution. You should also take note of the definition of personal items. This includes any household and personal items such as jewellery, and also includes your motor vehicle. We've highlighted some of the key definitions, but you really should take the time to look through them all and get familiar with them.
The first substantive clause of your will relates to the Executor and Trustee. Now, this is a person that you appoint to actually regulate the entire operation of your will. Their main responsibilities will be to actually find the last version of your will, the last original will, collecting all the assets of the estate and pay any liabilities. Depending on the value of your estate, there may actually be the obligation to obtain probate of the will, and again, this is a job for the Executor and Trustee. Probate is essentially the court's approval that the will that the Executor and Trustee is administering is in fact your last valid will. If you've got any questions in this regard, make sure you raise them as part of the online meeting.
If you have any minor children under 18, Clause 2 allows you to nominate a guardian to take care of them. This clause applies when both biological parents have passed away. You really should be comfortable with who you have nominated for your guardian, including any backups.
The next clause relates to your superannuation savings. Now, as we touched on earlier in the program, superannuation does not automatically form part of your estate. So what we've done under the will, and we'll step through this properly with you in the online meeting, is firstly acknowledge that fact, and then secondly directed the trustee and executor of your will to speak to the trustee of the superannuation fund and work out the most appropriate way to deal with your savings. If you've put in place a binding nomination, this might actually override the provisions of both your will and any instructions or directions that you might have articulated to your trustee. Again, the mechanisms for the way in which a binding nomination might work will be something that we'll walk through with you specifically in relation to your circumstances as part of the online meeting.
The next clause confirms who's going to receive the distribution of any personal items and specific gifts under your will. The will acknowledges that you might make verbal or written directions to your executors and trustees about these personal items, and that indicates that you can use your memo of directions to set out your wishes in this regard. The memo of directions is not legally binding, it is only morally binding, but it is a useful place to put in any directions that you'd like to complement the legal jargon in the will. In relation to your personal items, this is an excellent place to put any items that are of high sentimental value. However, if you have items that are of high financial value, or if you just want complete certainty, then you should include these items in the will as a specific gift. The memo of directions can be updated at any time without having to get a lawyer to sign off on it, so it's a good place to set out some of those other directions that you might like to include.
In many respects, even though it's a really short clause, the net estate provision is the most important provision in the entire document. What it does is take all of your assets, after liabilities are accounted for, and distribute them in accordance with the provisions of the will into the testamentary trusts that have been established. It's really important that you take the time to get familiar with the way these clauses work and also become familiar with the way in which the testamentary trusts operate. Testamentary trusts provide probably three really critical benefits that you need to be aware of before signing your will. The first one is the level of flexibility that it gives your trustee to manage your wealth for potentially the next 80 years following the date of death. You'll see when we go through some parts of the document that there are an enormous range of powers that the trustee will have in actually administering your estate via the testamentary trust. The other two really big benefits in relation to testamentary trusts relate to, firstly, asset protection. Testamentary trusts provide, depending on the circumstances, a really powerful way to protect the wealth from creditors in the event of business misadventure, but also in relation to relationship breakdowns. So in other words, former spouses attacking your wealth can effectively be prevented from doing so via the use of a testamentary trust. The final, main advantage of a testamentary trust relates to tax planning. Now, probably the easiest way to explain this is in relation to normal family trusts. Under a normal family trust, if you try to distribute any income down to a child who is under the age of 18, the maximum amount you can distribute without paying excessive tax is about $400. In relation to a testamentary trust, the position is almost the exact opposite. Indeed, children under a testamentary trust are effectively treated as adults for tax purposes. What this means is that they can get in excess of $20,000 a year income each and every year, effectively without paying any tax at all. So for obvious reasons, testamentary trusts can be a very powerful structure in the right circumstances for tax planning.
I'd like to explain to you how a testamentary trust operates. The fundamental feature of a testamentary trust is that you have a separation of control and the right to benefit from the trust property. The first role to consider is that of the trustee. The trustee has control of the trust property and decides which of the beneficiaries can receive distributions of income and capital. If you've chosen to include a principal in your will, then the role of principal will be to hire and fire the trustee, so it's effectively the ultimate controller of the trust. As I said before, the trustee can only give distributions of income and capital to the beneficiaries, and these are the people who can benefit from the trust. The trustee cannot make distributions to people who are not going to fall within the class of beneficiaries. The trustee also has absolute discretion about which of the beneficiaries can receive a distribution, and unless the trustee exercises its discretion in their favour, they have no claim on the assets of the trust.
One of the more technical provisions of your will relates to the definition of beneficiaries. Now, there's three main definitions that you need to be aware of: primary, secondary, and tertiary beneficiaries. Firstly, in relation to primary beneficiaries, these are the people that will be ultimately entitled to the assets of the testamentary trust if for some reason the trustee doesn't otherwise distribute the assets of the trust, so forgets or makes an invalid resolution. Normally, the primary beneficiaries will be people directly related to you, so for example, your current spouse or children. And the way in which those primary beneficiary provisions work will be something that the lawyer explains to you in a fair amount of detail as part of the online meeting. The other two categories of beneficiaries are largely driven by the amount of flexibility the trustee will have in actually administering the testamentary trust in the future. In relation to the secondary beneficiaries, you should again take the time to familiarise yourself with how they're crafted and raise any concerns that you might have with the lawyer during the online meeting. Some of the examples in this regard would include whether you want the spouses of your children to be potential beneficiaries, or indeed whether you want people like stepchildren or other more extended family members to be potential beneficiaries of the trust. The tertiary beneficiary definition is really driven by a lot of tax planning issues. So you'll see that there's reference to the ability to distribute to other trusts, and in particular, the ability to distribute to companies. That clause in tax planning sense is really quite critical, because if you have the ability under the testamentary trust to distribute to companies, that can effectively limit the tax rate to the top marginal rate of tax that a company pays, as opposed to what beneficiaries might individually pay, which currently can be anything around 20% more than what a company might pay.
It's important to note that the testamentary trust doesn't come into existence when you sign your will. It only starts once you pass away. Therefore, you won't have to worry about tax returns or other administrative compliance once you sign your will. In all Australian states other than South Australia, the trust can only last for 80 years from the date of death. If the law changes to allow a longer period, then your will is flexible enough to allow the trust to go for that longer period.
The remainder of the document sets out the powers that the trustees will have in actually running the estate as a whole, but more particularly the testamentary trust. You'll see that they're really comprehensive and designed to try to deal with any particular scenario that might come up during the lifetime of the trust. Probably the two most important ones to look at from a technical perspective are firstly in relation to tax planning. You'll see there's a number of provisions that are designed to ensure that the trustee has complete flexibility in relation to how to manage the tax of the trust on a year-to-year basis. The other really important part is that in relation to both the trustee role and any principal role, there are a series of events that we set out under the events of disqualification that actually can automatically remove the trustee or the principal if any of those events happen. Again, if you've got any questions at all in relation to how these provisions operate, make sure you raise them as part of the online meeting.
We've given you a cover page which confirms that your will in its draft form reflects your current testamentary intentions, even if it hasn't been formally signed. After your online meeting, we recommend that you sign and date the cover page and staple the draft will to it, which provides a safeguard in case something happens before you get to formally execute your will.
The final part of the will is in relation to the signing and witnessing provisions, and in many respects this is the most important part of the document. Unless you follow the directions that we give you precisely, there's every chance that your will actually be completely invalid despite all of the investment that you've made to this point. The signing instructions that we send out to you will set out a step-by-step process that you absolutely must follow exactly. On the very last page, and unlike a lot of other legal documentation, you actually need to date the document on the day that you sign it and then sign with your normal full signature. Once you've completed this, the two witnesses, who not only must be completely unrelated to you and must be with you through the entire signing process, must sign the very last page with their normal signature and then complete all of their contact details. Unless you follow this process exactly, as I said, there's every chance that your will not be valid. So if you've got any questions at all, please make sure you raise them either as part of the online meeting or contact us separately during the signing process.
Thank you for taking the time to watch this video. We hope you enjoy your online meeting.